I'm gonna read a letter to shed a little light on my experience that I've had with the county that I live in. Here it goes. Bear with me because it's a long letter. Dear worker, I am an individual human being standing on my natural, fundamental human rights and freedoms. This does not produce a cause of action against me. I am legally able to express, exercise, and protect my rights. I am seeking a remedy and cure on the trespassing of my constitutionally guaranteed rights. A civil violation has taken place while mishandling my case. Your office took the initiative to enforce a forbearance upon my rights and liberty by forcing me to obey provisions, rules, laws, or regulations. Following to this, you reduced my cash aid after I qualified to receive a certain dollar amount. I was coerced to sign an agreement prior to qualifying to receive public assistance. The agreement was advising me to agree to perform community service hours. However, if I am being asked to perform a service that automatically converts voluntary to involuntary and manipulating community service from the true intention of involuntary servitude. Because I was not given a choice, I do not get paid for those hours, but in return I receive the complete full dollar amount I originally qualified for prior being told to do the community service hours. This is now a violation of the Equal Work, Equal Pay Act, and as a volunteer, I have no one to correctly represent me, nor do I get equal protection of the law. Therefore, this Equal Work, Equal Pay Act does not afford to protect me. Because I signed the contract volunteering, it makes me ineligible to the equal protection of this right. You and your office are contributing to conspiracy and racketeering and obstruction of justice. The Civil Rights Office themselves overlap your office as an accomplice. They have told me they could not help me because I am not an employee. Neither did the Equal Employment Office for the same reason. According to the United States Constitution, you cannot just make up laws and regulations that go against the fundamental rights and freedoms or the charter rights. There has to be a provision in place, a measure that allows me to exercise these rights. The obligation is upon your office and the state party, and executive parties and all parties to give effect to these rights, and they must not take any actions aimed at the destruction or limitation of the rights. Simply stating that I owe an obligation or duty to the state is not a good reason to request me to perform a service to any rule, law, regulation of any kind, and even more, any reason to lower the amount I receive. I am no one's personal servant at their beck and call, and what is good for you may not be what is good for me. I have the right to choose where and what I will choose to volunteer my services without invasion of my rights and privacy. I am free from any kind of accusations of wrongdoing on my behalf, and particularly while expressing or exercising my rights, because a right can never be converted into a crime. You can choose to ignore and refuse to correct this illegal act. I am kindly informing you so that you are aware of where I stand, so that you are aware of what I am seeking. I am also notifying you that I revoke habeas corpus to have a court determine if I owe this duty or obligation to the provisions that are limiting and abridging my fundamental rights and freedoms. The Constitution of America and in the Constitution of California, it states that slavery in all their form are abolished and to be illegal, including servitude and involuntary servitude. You cannot force me to obey provisions that go against the Charter of Rights. Statutes and regulations cannot limit or abridge existing rights and fundamental freedoms. In no way, no case may a statute limit or abridge the Charter of Rights, nor any individual's full legal capacity. There can be no force on an individual to obey a statutory instrument that breaches the rule of law. You can try to use a statutory instrument to attempt to remove my full legal capacity. However, I am informing you that you may not, because they can never be rendered or taken away. They are inalienable. Every social worker and eligibility worker must respect the rule of law. In the International Covenant of the Civil and Political Rights, Article 9 states, anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court, in order that court may decide without delay on the lawfulness of his detention, and order his release if the detention is not lawful. An arrest is using legal authority to deprive a person of his or her freedom of movement, including the exercise of one's rights. To detain is a type of limitation which has been applied to my rights. Therefore, my rights are being deprived and limited because your office has claimed me to be uncooperative. through a civil procedure implying that I broke a regulation or enactment. This is the reason why I choose to revoke habeas corpus, to be brought forward before a court and have the court determine if the lawfulness of this charge or detention of exercising my rights is lawful, meaning do I owe an obligation to the state or enactment or not. The Constitution of California, Section 5, states that the privilege of the writ of habeas corpus shall not be suspended. You cannot place a limit or restriction upon this right. No one can be forced into involuntary servitude, including punishment for a crime. This particular common law of right to freedom and to liberty has been preserved for us through the International Covenant and subsequently expressed in the Constitution Act. When talking about the rights concerning involuntary servitude or servitude, this is a natural right. This is a right expressed through our liberty as men and women. We have a natural right to liberty. When standing under the rule of law, it does not matter the social pressure or the political pressure that is against me as an individual. I have the full legal capacity and owe no duty to the state. There was a failure to exercise reasonable care and behavior towards me in accordance with business laws, leading to business torts. Your office had no right to use simulated beliefs or opinion implying I conducted myself in an uncooperative manner. You claim I am non-compliant by not obeying a regulation or rule that is in breach of the Charter rights. Your actions of violation upon me is improper and unlawful, without liberty on my end of the agreement, that I was eligible to receive in the formal application process on the determination of qualifying for public benefits. There is no questioning the illegality of any rights and freedoms of liberty. I am seeking justice and requesting affirmative action on your office. Please consult with the next colleague with higher authority holding the most competence on regulation review within your jurisdiction prior to responding to this letter of communication. You and your office are not exclusive on having to obey the laws. Everything leading to the matters mentioned amount from the day I was coerced to an agreement that I truly was not in harmony with. I was in need of assistance and was not aware of the manipulation occurring at that time. Any lawful or legal agreement needs to be for a lawful purpose, and this purpose must be in a lawful manner. Otherwise, the contract is void. The court cannot force or allow a wrongdoer to force a contract on an innocent party. This now has turned into the infringement of my rights by the actions of your office, and the liability lies in the contract itself. I signed the contract for the same reason you knew I would sign the contract, and was taken advantage of at that moment, being vulnerable in the need of public assistance. Because I recognize my rights and choose not to perform the service and exercise my rights, you claim you hold legal authority to sanction me. Since this incident, I have had the opportunity to study my rights, and I am now exercising my rights in the United States of America. The Constitution of the United States, Amendment 10, clearly states the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Furthermore, in Amendment 14, Section 1, it states all persons born are naturalized in the United States and subject to the jurisdiction, therefore, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizen of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Even more to this, in Section 4, it states that the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States of any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. You have the opportunity to cure this sanction and give the correct amount I was applicable to receive. In Amendment 13, Section 1, it clearly says neither slavery nor involuntary servitude shall not exist within the United States or any place subject to their jurisdiction. If you choose to continue forbearance to correct this violation, then Section 2 of the Constitution indicates that Congress shall have the power to enforce this article by appropriate legislation. I have the right to